Good morning. We are on the record for 210512 GC NCDG Realty versus Brian Mitchell and Heather Burns. Appearances, please.
Good morning. Good morning, Your Honor. David Fantera on behalf of NCDG Realty and Property Management.
Ms. Burns, would you state your name for me, please? Ms. Burns? Ma'am, can you hear me?
I'm on for Charles Welch.
No, ma'am.
No.
Oh, there we go.
I'm not calling that case. I'm calling the case of NCDG versus Mitchell and Burns.
Yes.
Ms. Burns,
Yes, me and Mr. Mitchell are here.
would you state your names for me, please, individually?
Heather Lynn Burns.
Brian Gregory Mitchell.
Ms. Burns, can you turn your video back on for me, please?
I'm trying to figure out how. The video is.
This matter is scheduled for pre-trial conference. Have the parties had an opportunity to speak?
We have not, Your Honor.
Would you like to have a chance to speak in a breakout room?
Sure.
Ms. Burns,
Yes.
you're going to receive an invitation to join the plaintiff's attorney in the breakout room to discuss the case. When you come back in this main area, the case will be recalled.
Okay.
Thank you. Thank you, Mary Ann.
Thank you, Your Honor.
This is 210315 GC Jefferson Capital versus Charles Welch.
Yeah. Can you hear me, Your Honor? This is
Yes.
Nora Harrington, his daughter, and I don't think he's on because he's probably having issues with this. Because I don't hear him.
Ma'am, why are you on?
That's my father. My father has some mild cognitive impairment, and I'm just trying to assist him with the case.
Where is he?
He's probably at home. I'm in Arizona. I'm in Phoenix. My father's in Romulus at home. I've instructed him on how to get onto the Zoom meeting, but apparently he's having some difficulty.
Then, ma'am, what I'll have you do is get off of this call him and get him on. Unless you're a licensed attorney, you cannot represent him in this matter.
Even though I'm his power of attorney for all matters at this point because of his cognitive impairment.
Correct.
Oh, gosh.
Is there someone in Romulus that can be of assistance to him?
Yeah, my 80-year-old mother, which is not of much help. So, can it be rescheduled at all or no? Not at this point?
I would need Mr. Welch to come on, ma'am.
How much time do we have to get him back on?
Well, I have other cases ready and waiting. We'll be on the record till probably 10 o'clock.
Okay, let me get him, I'm gonna try to walk him through it.
Okay.
He's gonna be very confused though. So is there
Okay.
any way that I can have my brother there with him?
Yes, ma'am, that's fine. But Ms.
Okay.
Harrington, going forward, please remember, even though we're on Zoom, this is actually a courtroom. And when you shout out of order, it disrupts the flow of the court, okay?
I apologize. I'm forgetting.
No
that.
worries.
Thank you.
Thank you.
Okay.
This is 151333 GC Credit Acceptance versus Crystal Price.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Good morning, Ms. Olivier. Ms. Price?
Good morning, Your Honor. Crystal Price.
Good morning. This matter was scheduled for an objection to garnishment and motion to satisfy judgment. Are the parties ready to proceed this morning?
Yes, Your Honor.
Before we begin, I will disclose to the parties that Ms. Price, I know Ms. Olivier as another practicing attorney for years now. And Ms. Olivier, I know Ms. Price from the community. We don't have any special social relationship, but I wanted to disclose both relationships on the record. Knowing this, Ms. Olivier, are you still prepared to proceed this morning?
Yes, Your Honor.
And Ms. Price, are you still prepared to proceed this morning?
Yes,
Ms. Price, this was your objection to garnishment.
yes.
What's the basis of your objection?
My basic objection is, as I stated in my affidavit, is that I affirm that I have a right to defend this action, but the right was violated because I was never served a copy of the request of writ for garnishment for income tax refund credit entered by the court on July 28, 2020. I was notified of this garnishment action by the Michigan Department of Treasury on March 13, 2021. I affirm that the total amount of the judgment entered on August 26, 2015 for $8,209.20 has been paid. I also affirm that the total amount, including interest of the writ issued July 28, 2020 is $2681.74, and I have the exhibits there. I have also submitted and affirmed a total amount of the writ is incorrect based upon the following truth of facts. The Public Credit Bureau, TransUnion, and Equifax shows that the plaintiff's report count is paid in full. The exhibits are also there. The plaintiff received a payment in the amount of $3,352.30 from JP Mortgage Bank. November the 20th, the exhibit is there. The plaintiff received an amount of $1,390, $1,393, $1,696, and $200. They have already received from the Michigan Department of Treasury. In the exhibit dated March 26, 2021, and disclosure statements. Also, the letter from the Michigan Department of Treasury dated March 26 shows another garnishee portfolio recover. However, plaintiff received the withheld funds, not portfolio recovery. And the exhibit is there under the objection to garnishment of the $1,390 to the total. And the total received by the plaintiff for the judgment entered on August 26 is $8,031.30. The balance due on the judgment entered August 26 is $177.90. They are currently holding $1,705 is being held by the Michigan Department of Treasury until this matter is resolved. I affirm that I am experiencing extreme financial and other personal hardships due to COVID-19 pandemic. And I'm also confirming that I'm still on, I am currently and have been ever since this action has been brought against me back in 2015, that I'm on a Canada pension. And that was not addressed in my hearing. And I affirm that I am requesting that the court enter a written order requiring plaintiff to release me from the income tax refund credit garnishment and or any bank garnishment in exchange for my agreement to make the final payment of $177.90, which is also in my exhibit 7, to release of garnishment and certificate of satisfied judgment form. I also want the court to know, I don't know what happened, but I don't see anybody.
You don't
On the
see
screen.
one?
Oh, now I see you. Okay, it was like, okay. And I also want to inform the court, I have tried on several occasions in the last 2 years with credit acceptance attorneys, which I was denied to speak to them when this first started back in 2015, but also in the last 2 years, last year and this year, I have diligently tried to contact credit acceptance attorneys. And I spoke to a Stacey Ann Lawrence, her supervisor, Anne Marie Robinson, and her supervisor, David Briers, in this matter, requesting receipts of what I paid, requesting foreign history, requesting documents to show. When I spoke to the Michigan Treasury, they said that I would have to call them to have it amended. They refused to amend it. They refused to communicate with me. I've never received any garnishments by mail. And in the Register of Actions, if you look, you see that there's garnishments issued to Bank of America. Bank of America is not even my bank. And it's just so many different things. And when you look back in the file and you see where they said that they served me, if you look at one of the documents, it clearly shows that the stamp for the court is side, the stamp that they sent me, these documents, on the label of the envelope, my name is crooked. So there's no possible way. It was just like, you can see all the different insufficiencies that has gone on with this case. And when I tried to file this case here, I was stopped at the door saying I couldn't file it. And as I was driving home, I received a phone call from the court administrator, and she said, "Oh, I talked to the chief judge and he said you can file the motion." I don't understand why I'm being stopped to be heard, my rights to be heard. I don't understand it. And I don't understand why the attorneys on the other side wouldn't provide me with any information regarding this case or anything. They said I wasn't entitled to it. How could I not be entitled to something that you're saying I owed you? And they said they were entitled to charge me all this interest. And I just don't understand it. I don't understand it. And even in her complaint, even in Lynn's complaint, in the beginning of her complaint, she's got that I owe $67,72.68 plus interest to date of $12,226.57. Where is all this coming from? And I have all these documents of their, when I ordered my records from the court to get this case in front of a judge, they told me that my records were destroyed. How can my motions be destroyed? And I got 2 denies in 2015 or 16 and 17. The judge denied me both of my all my motions. So how are my motions been destroyed? I don't understand this.
Ms. Price, I'll respond to the things that the allegations you made regarding the court. Your file hasn't been destroyed. I'm sitting here right now with a file that's more than 1.5 inches thick. No one has been denied the opportunity to file anything with the court because of COVID. Filings are being handled slightly differently.
I'm sorry.
That's the only thing that the court can respond to. Ms. Olivier, as to the objection to garnishment, your response.
Yes, thank you, Your Honor. The defendant brought in a whole ton of issues, but I'm only going to focus on what she actually put in her objection in her motion. I first want to start off with saying that plaintiff did receive an amended disclosure from the state of Michigan indicating that the amount payable is 0. So plaintiff will not be receiving anything pursuant to that tax garnishment. With regard to the defendant's right to object to the garnishment, it was not denied. It's being heard right now. With regard to what the balance is, plaintiff did attach a copy of a payment history to its answer, and it does include the statutory interest that plaintiff is allowed by law to collect. So plaintiff contends that defendant's objections to garnishment, motion to release garnishment, and satisfied judgment should be denied.
Anything else briefly, Ms. Price?
I was denied when I went to court in 2015 and 16 and 17. That's what I'm talking about. I'm not talking about here now. This debt has been paid, and I am on a disability, and it clearly says in the garnishment that if you are on any type of a disability or whatever, you can be exempt, or however it's worded. I don't have the words exactly in front of me. I'm not disputing the fact that I owed the $6,000, but what I am is that this debt has been paid, because when my bank paid the $3,325 $3,250, that brought that down to 3,000. So how am I still owing? How am I still owing $2,700? I don't understand this. And how come these guys are charging me interest on this judgment? I don't understand. I was never given the opportunity to defend my case back then. It was just denied. And you have the documents there. And I received a letter from the court, Mariah, a court administrator. She said, some of the documents you requested have been destroyed in accordance with the retention of disposal schedule approved by the state of Michigan. Post-judgment filings are kept for 1 year from the date of filing and then destroyed. Exhibits submitted to the court are retained for 56 days after conclusion of the trial and then destroyed. Now, what I don't understand is how are the motions, I have the denied by the judge to deny, I have the denials, but the motions have been destroyed. Why? I don't understand that. So yes, they have been destroyed.
Ms. Price. This is your file, ma'am. This is your file. I review the filing that you made to the court on April the 4th. And
You keep cutting out.
hold on 1 second, ma'am.
I don't see you.
Your filings on April the 5th of this year, April the 6th of this year. Plaintiff's response, which included an accounting. The matter is before the court this morning only on the objection to the tax garnishment. Your allegation is that this debt has been paid. It has not been paid. The court has had the opportunity to review all of the pleadings relevant to the objection to garnishment. Your objection to garnishment and your motion to satisfy the judgment are both denied in their entirety. Anything else this morning, Ms. Price?
That's it. Thank you.
Anything else, Ms. Olivier?
I'm sorry.
Anything else?
Do you have an order in front of you, or do you need my office to submit one under the 7-day rule?
I don't have one. If your office would submit one, I greatly appreciate it. Thank you, ma'am.
Thank you.
Have a good day.
Thank you.
Mr. Fantera, Ms. Burns, and Mr. Mitchell are back. Are you ready to proceed on NCDG?
Yes, Your Honor.
Recalling 210512, your appearances have already been placed on the record. You've had an opportunity to speak.
Yes, we did not resolve it, but I told them my position. I made sure they had my phone number, and I said, if they want to, make an offer to resolve this, please call me. But we weren't able to get it resolved today.
The matter was scheduled for pretrial this morning. So although you're unable to resolve it, is there any way that the court can assist you in moving towards a resolution?
You mean now, or at a settlement / case evaluation, or that type of thing?
Well, Mr. Fantera, that would be up to the parties. If there's any way that you believe the court can be beneficial in resolving the matter.
I think maybe a settlement conference might do some good.
Ms. Burns?
Yes. I don't know. I'd have to talk to him. We're gonna have to crunch some numbers and see how we feel about it.
Settlement conference or an adjourned pretrial conference?
You wanna do a settlement?
That's fine.
Yeah.
Mary Ann? What would be the adjourned date? Thank you, ma'am.
So we can do that as a settlement conference, Your Honor, rather than an adjourned pretrial?
We can do that at the settlement conference. She's just looking on the first Tuesday in June would be that next date. June 1st at 9 o'clock.
All right.
That'd be fine.
Is there anything else that you need this morning, Mr. Fantera?
Nope, I think we're good, Your Honor.
Mr. Mitchell?
Good.
Ms. Burns?
Good. We're good.
We're all set. We'll see you back here on June 1st.
Thank you very
Thank
much,
you.
Your Honor. Good to see you.
Good to see you. Mary Ann, if you want to pull those two in, I don't know if that's Mr. Welch trying to make a reappearance.
Hi, the person that has Hanks.
Yes,
What is your name, please?
Kim Burrows.
Thank you, Marianne.
You're welcome.
This is 165943 GC Grove Road versus Kim Burrows.
Yes, ma'am.
Your appearances, please. Ms. Martin?
I'm sorry, it's Miss Burrows.
Yes, ma'am.
My apologies, Your Honor. Good morning, Your Honor. Elizabeth Martin appearing on behalf of the plaintiff.
Would you state your name for me, please?
Kim Burrows.
Ms. Burrows, this matter is scheduled this morning for pretrial conference. I'm sorry, objection to garnishment. Before we begin, I need to disclose to you that I know Ms. Martin, the attorney, Ms. Martin. I've worked with her in the past and we know each other socially.
Okay.
Disclosing that to you, I do believe that the court is able to be unbiased in resolving the matter this morning and hearing your objection to garnishment. Do you still wish to proceed this morning, or would you like the matter reassigned to another judge?
I can work with you. That's fine.
Okay. Ms. Burrows, this was your objection to the garnishment. What's the basis of your objection, ma'am?
My objection is that I had insurance and my insurance paid for everything that they had asked for, and two, I got the insurance that they asked me to get, which was 100 or whatever, however, I don't even remember how much it was. And three, the fire that happened in there was never my fault. The fire report says unknown cause. It's all public records.
Ms. Burrows,
Yes, ma'am.
when are you alleging that your insurance company paid the amount that's requested as due?
When I had insurance, when I stayed there, they paid stuff. My insurance paid for whatever they had asked for. I don't know my insurance, what they asked me for as far as my insurance. I can't remember how much it was because it was so long ago that I can't even remember what it was, but I know that fire report said unknown cause in it. Like right now, they got an apartment down there right now, burnt down again. So now I'm going to court, feeling like they trying to get money from me that I don't even have. I'm not even working. I'm on medical. I just buried my daughter. So, and right now they got me diagnosed with depression and anxiety. I don't know when I'm going back to work right now.
Condolences to you, Ms. Burrows, on the loss of your daughter.
Thank you.
Was there anything else you wanted to say about the basis of your objection to the garnishment?
And if I do owe something, I'm not able to pay anything right at this moment anyway. I'm not even really getting paid. I was in a car accident 3 years ago. Went back to work in April. Then my daughter passed in September, and I still haven't been back to work. I'm only getting 55% of my pay, which is nothing because when I bring it home, it's nothing but like $200. I'm living, I'm barely making it right now. I've been trying to get help or whatever, but it's hard.
So I don't know what else to possibly do, but I feel like I don't owe them. I had the insurance. I had the amount of insurance that they asked me to have over there. So, I mean, I don't know.
Anything else, ma'am?
No, ma'am.
Ms. Martin, your response?
Your Honor, this judgment was entered over 4 years ago in regards to this matter. The underlying action can't be attacked in an objection to garnishment pursuant to 3.101K. Furthermore, I'm not sure of the court. I hope you received my response. It was sent by overnight mail and it was delivered on April 28th, which included an accounting. A copy was also sent to Ms. Burrows at her correct address because the court notice had a former address. Is that correct, Ms. Burrows?
Yes.
The objection to garnishment, Your Honor, contained the accounting. And Ms. Burrows has been garnished at least 4 times on this particular matter, has never raised an objection. She has received credit. She has received credit for all her payments that have been made, and I believe there is no valid objection to the garnishment at this time.
Anything else? Ms. Martin, anything else?
Not at this time, Your Honor.
Ms. Burrows, you had a response?
Yes, and the only reason for that garnishment was because I, at the time, did not know that I could write in or respond to anything. I thought that I didn't even know nothing back then. I know different now. I didn't even know that I could write in or respond to any garnishment like that. I didn't even know. So that's why that happened. I wouldn't have let that happen if I would have wrote in like I did this time.
Anything else, Ms. Burrows?
No, ma'am.
Ms. Burrows, on March 30th, you submitted a letter to the court requesting a Zoom hearing indicating that you do not owe nothing. The court took that as an objection to garnishment and scheduled the matter accordingly. Court did receive a response from plaintiff's office on April 29, 2021, which did attach an accounting. Ms. Martin has correctly cited the court rule that provides that your objection to garnishment can't be used to attack the underlying judgment. Your assertion that you had insurance that should have covered this debt is an attempt to attack the underlying judgment, which is not allowed at this time. Inasmuch as there's been an accounting provided that shows the total that remains due and owing as $6,633.15. The court's going to deny your objection to the garnishment. Any funds currently held shall be released to plaintiff's attorney. The court will prepare an order. Anything else, Ms. Burrows?
No, I just don't feel like that's fair as far as garnishment when I'm not even getting a check.
If you're not getting anything, Ms. Burrows, there's nothing for them to take.
I'd rather set up a payment plan than have them garnish me.
That's something between you and the plaintiff's attorney. If that's the avenue you want to pursue.
Miss, it does the other, I can't remember her name. What is?
Martin.
Miss Martin, does she want to do that with me?
That's something that you can talk about offline with her. That's not before the court.
Oh, okay.
Do you want to come, Ms. Martin?
Yes, I'm sorry, Your Honor. I was just going to ask if Ms. Burrows wants to call my office. Later this afternoon, I have 2 other cases this morning, but later this morning, I'll be glad to speak with you. Please note, Ms. Burrows, we did receive a check though on 4/16 for $169.07.
Okay. See, I didn't even know that.
Okay, that's why I wanted to give you that information. Your Honor, if we can just make sure also that Ms. Burrows' address is updated, please, in the file.
The court has Parkwood Street.
Yes, ma'am.
Okay.
Very
Anything
good.
else?
No, that's it.
We're all set. Have a good day, Ms. Burrows.
Thank you.
Thank you, Your Honor.
This is 210536 GC Grove Road Associates versus Keisha Jones.
Good morning, Your Honor. Elizabeth Martin appearing on behalf of the plaintiff.
Ms. Jones, would you state your name for the record, please?
Keisha Jones.
Ms. Jones, I'm not sure if you were in the courtroom. The court previously disclosed that I know Ms. Martin, the attorney, Ms. Martin, have known her for some years. We've worked together previously and we've seen each other socially. I'm required to disclose that, knowing that the court still contends that I'm able to sit in this matter fairly, unbiasedly. And I wanted to disclose that and ask, are you comfortable proceeding with me, or would you rather this case be reassigned?
I'll proceed.
Okay. Ms. Martin, are you ready to proceed?
Yes, I am, Your Honor.
Have the parties had an opportunity to speak?
No, Your Honor.
Would that be beneficial this morning?
I'd be willing to speak with Ms. Jones.
Ms. Jones, you're going to receive an invitation to go into the breakout room.
Okay.
You hit that join button, you'll meet the attorney in that room. You'll discuss the matter and see if you're able to resolve it or narrow the issues between the parties. And when you come back in, the case will be recalled, okay?
Okay.
Thank you. Mary Ann, if you would put them into a breakout room, I'd appreciate it. I think Director Luke is here for the tow case. Thank you.
Okay, we're on. I gotta go.
Mr. Stidham, what case are you here for?
Good morning, Your Honor. I'm here for Auto Owners Insurance Company versus J&T Towing.
Okay. We're not quite ready. I have a couple of smaller cases still pending, so if you would sit tight.
Very well.
Thank you.
Thank you.
I haven't seen Mr. Welch come back on. There's no one else in our waiting room. I did tell her 10 o'clock. Ms. Trickhurst, do you have any objection to hanging around for a little bit longer? You're on mute, ma'am.
Good morning, Judge.
Good
At the
morning,
court's pleasure.
If you don't mind, I have a couple of other things, and if they're not back on, I would say within a half an hour, I'll call the case and we'll proceed
Okay.
from there. If you have some other things to do.
Sounds good. I'll find something to do, Judge. I'll just hang out.
Thank you, ma'am.
Thank you.
This is 210530 GC Harley Davidson Credit Corporation versus Leonard Gouy and Diane Frazier. This is 210530 GC Harley Davidson versus Leonard, last name Gouine, and Diane Frazier, Frazer. This matter was scheduled for 9:15. It's now 9:33 by the court's clock. No one has appeared on the plaintiff's motion for restraining order. Plaintiff's motion will be deemed abandoned and denied. Marianne, I don't see anybody else. This is 211337 GZ, Auto Owners Insurance versus JT Towing, doing business as Crova Towing, and Sumter Township Police Department. Your appearances, please.
Good morning, Your Honor. Jared and Jessica on behalf of the petitioner.
Good morning, Your Honor. Thomas Stidham appearing on behalf of the respondent, J&T Towing, doing business as Crova Towing.
Director Luke here for Sumter Township.
And Your Honor, I have several of my representatives of my client here as well. I don't know if you want them to stay on mute and off the screen until the hearing begins, or
The hearing is beginning.
okay.
Hence me calling the case. I see Mr. and Ms. Bocan. We're here this morning on auto owners petition regarding impoundment of motor vehicle, when this matter was originally filed back on March the 16th.
It kicked us out.
Did you need more time?
Yes, we're very close, Your Honor.
Marianne, I'll move you back into the breakout room.
Thank you, Your Honor.
J&T Towing, doing business as Crova Towing, was the only listed respondent. Petitioner later filed a motion to amend petition and add respondent. Have the parties received a copy of the petitioner's motion? Mr. Stidham?
Your Honor, I did not, but I was informed this morning that my client did. I have not seen it. I will notify the court that I did contact or reach out to counsel for Sumter Township, because I saw in the plaintiff's brief that Sumter was requesting some relief against themselves. I think the chief is here as a result of a subpoena that had been issued for his appearance this morning.
The chief is here. My next question to him was going to be, did he reach out to Sumter's counsel? And would someone be appearing on behalf of the township this morning?
That question for me, Your Honor.
Yes, sir.
I'm here on the subpoena that was delivered, I don't know, a couple of weeks ago to me regarding auto owners versus J&T Towing. I spoke to Township Attorney Rob Young about 5 minutes ago, right before the meeting, and he let me know that he did talk to, I believe, Mr. Stidham, who was notified at that point, the first notification that Sumter Township is now part of this lawsuit. Prior to this, I had never, that was not information that was relayed to me.
It's actually the petitioner's motion to add Sumter Township that was noticed up for hearing this morning.
The information I have is to appear on the subpoena that was delivered, like I said, about 3 weeks ago.
Okay, as to your motion,
Thank you, Your Honor. It is our motion to amend the petition to add respondent pursuant to the Motor Vehicle Code statutes, that the hearing, the purpose of the hearing is to determine whether the police agency, towing agency acted properly under MCL 257.252 subsection F1. Thus, Sumter Township would be a necessary party to the petition pursuant to the statute upon which this hearing was originally filed. Moreover, leave shall be freely given pursuant to MCR 2.118, and thus we are requesting leave to add them as a party to the petition and pursuant to the statute. Also, where I'm seeking to amend the petition itself to contest the determined that the vehicle was actually abandoned correctly under the Motor Vehicle Code, MCL 257.252D. And therefore, petitioner respectfully requests that the court grant the motion and add Sumter Township as a party to this petition.
your motion is granted.
Thank you, Your Honor.
And inasmuch as Sumter PD is just now added to the petition, We're going to need to adjourn this matter
And
to
absolutely,
allow
Your Honor.
time for service of documents upon them. We have some flexibility in our schedule. How much time do you need to get them served?
I can have that, if they can get an email, I can have that sent to them right now and, allow whatever time they necessarily need and would like to request.
Mary Ann? June 1st feels awfully far out. What does that's not too much better. What does May 25th look like? I'm open. Are you sure? Mr. Stidham, are you available on May the 25th?
I am, Your Honor. Are my witnesses available? Are they in town?
Yes, we are.
Nodding, okay. At 9 a.m.?
Yes, Your Honor.
We'll adjourn this matter to May 25th, 2021 at 9 a.m. to give petitioner time to serve Sumter Township and any additions you need to make pursuant to the court granting the motion to add Sumter as a party. Anything else on behalf of auto owners?
No, Your Honor. Thank you.
Anything else on behalf of J&T Towing?
No, Your Honor.
Thank you. Mr. Stidham? Thank you so much, sir. Chief Luke? I didn't stop to ask, are you available on the 25th?
Of course I am.
And if you relay same to Mr. Young, I'm sure he'll get a copy of the pleading shortly. We'll see you back here on the 25th.
Okay, thank you.
Thank you.
And just for record, the attorney's name is Rob Young.
Yes,
Okay,
Yes.
thank you.
good to see you, Mr. and Mrs. Bokan.
Same here.
you.
The date.
Thank you, Your Honor.
Thank you, Your Honor.
The breakout room. Ms. Jones and Ms. Martin.
Yes.
Did
Could we
need
go
to
back in
into the
for-
breakout? Yep, she's sending you back right now.
Thank you very much, Your Honor.
Thanks.
Ms. Trickhart, someone's here for Mr. Welch.
Oh, okay.
Ms. Martin, can you accept the invitation to go in the breakout room?
Ms. Andruski, did you need something else? Okay, 210315, he's still connecting. We're having issues with connection this morning, it seems. Mr. Welch,
Yes. Yes,
are you able to turn your video on?
start with video. Okay. Got it.
Thank you.
Can you see me?
Not quite yet.
Allow Zoom to take pictures, record. Can you see me now?
There we are. Thank you, sir. This is 210315 GC Jefferson Capital versus Charles Welch. Appearances, please.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, STRICHARTZ, P440018, on behalf of the plaintiff.
Thank you, ma'am. And Mr. Welch, would you state your name?
Charles Welch.
Mr. Welch, this case was scheduled for pretrial conference this morning, and before we begin, I want to disclose to you that the court is associated with the plaintiff's attorney in this case, Ms. Strickhartz. We've worked together in the past and we've seen each other socially. Although I do not believe that that would impact my ability to sit on the case this morning, I wanted to disclose that to you and offer the opportunity for this matter to be assigned to another judge. And I want to ask if you're comfortable with me proceeding this morning, or would you rather the case be reassigned?
Fine.
Thank you, sir. Is there someone there assisting you this morning?
No, just my wife here.
Okay. And are you ready to proceed with the pretrial?
Yeah.
Okay. Ms. Strickhartz, did you receive the defendant's answer in this matter?
Yes, we've received an answer, Your Honor, that doesn't dispute owing the debt. We, in response, sent a consent judgment. We didn't receive it back. And we haven't had any further contact or communication at all.
Would you like the opportunity to speak to Mr. Welch in the breakout room this morning? Would that be beneficial?
I believe so.
Mr. Welch, you're going to see an invitation to join a breakout room that'll take you into another screen that you'll talk to the plaintiff's attorney and see if you're able to resolve this matter. And when you're done speaking with her, you'll come back in this room with me.
Okay.
Okay, you'll see an invitation pop up in just a second.
Okay, I push this join now, right?
Yes, sir. We're back on the record on 210536 GC Grove Road versus Jones. Did you have enough time to speak in the breakout room this morning?
Yes.
Yes, Your Honor.
You ready to proceed?
Yes, Your Honor. We're pleased to inform the court that we've had the matter resolved in totality.
The terms of the settlement?
Your Honor, the parties have agreed to a consent judgment. The damages will be $1,936.45. We have court costs of $105.31, statutory attorney fee of $75, for a total judgment of $2,116.66. The defendant has been informed that post-judgment interest will run on this judgment. Also, that the plaintiff is not waiving the right to file an income tax garnishment. The parties have also agreed to a payment plan. The payment plan will be, Ms. Jones will remit $180.31 on May 9th.
Hello.
Then,
Mr. Welch, what happened?
I don't know. I just got moved to another courtroom or something.
If you'll accept the invitation to go back into the breakout room, the attorney will be in there.
Ms. Martin, $180.31 on May 9th, and then thereafter?
no, Your Honor. Then payment plan of $150 will begin on September 24th and the 24th of each month thereafter until the judgment's paid. Ms. Jones has indicated that she will not be working for a few months in the summer due to her work schedule. Ms. Jones, is everything I say accurate
Correct.
and reflective of our agreement?
Yes.
Ms. Jones, those were the total amounts that you agreed to along with the payment plan?
Correct. Yes.
And Ms. Martin, are you going to mail her the consent judgment for her to sign and return to your office?
Your Honor, I could do it that way or do it under the 7-day rule, whichever the court would prefer. Or I can just, okay. Ms. Jones, I'll mail you out the consent judgment today. There'll be a stamped addressed envelope. If you would just review it, make sure it's correct. If there's any issues, you feel free to give me a call. Otherwise, I'd please ask that you sign it and return it to my office immediately.
Okay.
And then it'll be filed with the court. Then a copy will be forwarded to you.
Okay.
Anything else, Ms. Martin?
No, Your Honor.
Anything else, Ms. Jones?
No.
Thank you so much for working to resolve the matter this morning. The court will note that consent judgment is forthcoming. Thank you much. You both have a great afternoon.
You too.
Thank you
Thank
very
you.
much, Your Honor.
Thank you.
Mr. Welch?
Yes,
I don't know why it took me out of there, but here we are again.
okay.
So, Mr. Welch, are you interested in trying to resolve this today?
Yeah,
Okay. Mr. Welch, are you, how would you like to resolve it?
how much to owe?
The amount owing without my client's costs are $2,843.73.
So what would be the best way to resolve it? Is,
Well, I sent you a letter that had a form with it. Did you get that?
I don't recall getting it.
Okay, it had a payment plan. It looked like this. Let me hold this up so you can see it. It looked like this.
Yeah,
And it had a payment plan of $75 monthly on it for you to pay off the principal damage, the 2,843 and 73 cents, plus $124.36 in court costs. And then a $75 attorney fee for a total judgment of $3,043.09. And it had a payment plan of $75 monthly. Can you make that payment plan?
make the payment plan $75 a month.
Mhm.
Okay.
We're back on the record on 210315 GC Jefferson Capital versus Welch. The parties have been in the breakout room. It seems as if there was some trouble staying in that breakout room. Mr. Welch, I've listened to the conversation regarding a possible consent judgment with payment plans of $75 per month. Is that how you wish to proceed this morning?
Yeah,
Ms. Trickhart, when was that consent judgment mailed to Mr. Welch?
That went out to him, Judge, on March 19th. March 19th.
March 19th?
Yes. So I can place the terms on the record, Judge, and then submit it under 7-day if it pleases the court, or by email or fax.
They will accept the email. Mr. Welch, who's that in the background?
it's my wife.
She's just trying to give you a little assistance?
Yeah.
Okay. Ms. Strickhart's the terms?
We didn't have a start date, Your Honor, of the $75 monthly. So I'm wondering when Mr. Welch would want to begin payments, in May or in June?
May,
May, in the middle or towards the end of the month?
towards the end, that would be better.
So May 28th and the 28th of each month?
5/28,
Is that good, sir?
yeah, that's good.
And what is the
Okay.
principal amount due, Ms. Strickhart's?
Okay, yes, Your Honor. The principal damages is paid for in the complaint, $2,843.73. Costs totaling $124.36. That's comprised of the filing fee of $75 and the service fee of $49.36. And then there's the attorney fee of $75 for a total judgment of $3,043.09. That's going to be paid at $75 monthly beginning May 28th of this year and the 28th of each month after until paid, with interest accruing from the date of entry of judgment, currently resting at the statutory 6 months, 1.33%.
And what was the date that's starting?
May the 20th.
May 28th.
Mr. Welch, were you able to hear the dollar amounts that Ms. Strickhart just placed on the record?
$3,043 total.
Yes, sir. And is that what you wish to agree to?
Yes,
What'll happen, sir, is that Ms. Strickhart is going to mail the proposed consent judgment to the court with those terms. She'll also mail you a copy. If it is in fact what you agreed to, you don't need to do anything else. If you think that anything is wrong with what she submits, you need to notify the court. Otherwise, after the court receives it, we'll sign it and then a copy will be mailed to you.
And we'll
So
pay
let's just-
$75 a month.
I'm sorry, sir?
We'll pay $75 a month, right?
Correct, sir, starting on May the 28th.
For, in a total of $3,043.
Yes, sir.
Okay.
Anything else, Ms. Strickhurst?
Judge, then we'll just send it under 7-day then. by
That'd be
mail.
great.
Okay.
Thank
Okay,
you.
thank you, Your Honor.
Anything else, Mr. Welch?
No,
We're all set. Have a good day, sir.
you too. Thank you.
Thank you.
Person with Moto G Stylus, can you hear me?
Hello?
Hello, the Moto G Stylus. What is your name, please?
Bradley Tanner?
Thank you.
Mr. Groen, what are you here for?
I am
Excuse me?
here on the Citibank Brenda Moner pretrial.
Thank you. This is 211084 GC Citibank versus Brenda Moner, AKA Brenda Meeks. The
Good
parent-
morning, good morning, Your Honor. Brian Gruen, GROEN, P number is 56673 on behalf of plaintiff Citibank.
Ms. Moner,
Yes,
can you turn your video on for me, please?
turn it on.
Yes, ma'am.
That's what I'm trying to figure out how to do. Oh, here it is.
Wonderful,
Okay.
wonderful. Could you state your name for me, please?
Brenda, last name Monet, Moner.
Ma'am, this matter is scheduled for pretrial conference this morning. Have the parties had an opportunity to speak?
We have not, Your Honor.
Would that be beneficial, sir?
I always appreciate the opportunity to see if we can work something out or not.
Ms. Monet, you believe that would be beneficial to speak to the attorney this morning?
Oh, absolutely.
You'll see an invitation to go into the breakout room. Please join him there, and when you're done, come back here and we'll continue with the pretrial.
Sounds good, Your Honor.
Thank you. This is 210942 GC Security Credit Union versus Bradley Tanner.
Morning, Your Honor. Wesley Neal on behalf of the Security Credit Union, P number 80307.
Mr. Tanner,
Yes, ma'am.
turn your video on for me, please.
How do I do that?
I'm gonna send you a little button and you click it and I'll help you start your video. Wonderful. Would you state your name for me, please?
Yes, ma'am. It's Bradley Tanner.
Mr. Tanner, this matter is scheduled for pretrial conference this morning. Have you had an opportunity to speak to plaintiff's attorney?
No, I haven't.
Mr. Neal, do you think it would be beneficial to speak to Mr. Tanner?
Absolutely, Your Honor.
Mr. Tanner, do you think it would be beneficial?
I hope so, yes.
You'll receive an invitation to go into a breakout room. If you click that button and join the attorney there, you'll have an opportunity to speak. And when you are done, you'll come back here and we'll pick up on the pretrial.
Thank you, Your Honor.
Thank you,
Thank you.
sir. Here's what I'm wondering. If there is a mechanism where people can check themselves in for virtual court so that the court knows when parties have connected and are ready, and then the court can call them in the order in which they checked in and are ready. Or if there's a way for them to check themselves in and put themselves into a breakout room. Not necessarily on the Zoom platform, but on a platform.
Can you hear me?
Mr. Goen and Ms. Monet, was that enough time in the breakout room?
Well, we're kind of going in circles, but I think maybe put us back in for another couple minutes and I'll try to wrap it up with her.
Ms. Monet? Okay. Mr. Neal and Mr. Tanner. Oh, you put everybody back in. What is?
I see no point. He seems like he just wants.
What was that about a cop case? What was I hearing? Ms. Monet, you're fine. Stay where you are. She'll bring the attorney back out. Marianne? No, what? Oh.
Hello?
Ms. Monet?
Miss Monet, was there a button to join the breakout room? Ma'am?
Yes.
Is there a button that says join breakout room?
He's not willing to discuss anything. He just wants to put the money where he wants to put the money. He's not taking what I'm saying into consideration. It says join breakout room.
Yes, click that.
I'm just asking because we are running live on YouTube and I never know who's watching, and someone might have a better idea about how to get people checked in and connected and situated. I'm thinking back to in-person court where you would check in with the court officer or the secretary and they would send you out to talk before you even had the case called. So it wasn't come in, talk to us, and then go to the breakout, come back, go to the breakout. There has to be a different way to do it. And I've seen some courts pull everyone in at the same time, and when they match up, do it that way, or just call it in the order of the docket. And just curious how other courts are doing it and what seems to work the most smoothly. Does it matter by what the docket is? Mr. Graham, was Ms. Monet coming back? Were you not done talking?
I was in there by myself for a while and then she appeared and then her video was basically frozen. So I couldn't tell if she could hear me or not. So then she left again. So I'm not for sure what's going on.
I don't see her back yet, and I don't control that.
Yeah, maybe she had to hang up and just resume in.
If she's still in the breakout room, I'll have Mary Ann close that room and bring Miss Monet out.
Okay, she left before I left, so that's why I left, because all of a sudden like she was gone. So technology, you have to love it, right?
Exactly. Uh-oh. Thank you, ma'am. Mr. Tanner's back first, so when Miss Monet comes, we'll recall that. But recalling security credit versus Bradley Tanner, 210942. Did the parties have enough time in the breakout room?
I believe so, Your Honor. The defendant was kind enough to give me his contact information. At this point, we do not have a resolution, and I'm just going to ask for some time for discovery and then probably a date for a motion for summary disposition.
Mr. Tanner, were you able to hear what the attorney just did?
Yeah,
How long for discovery, sir?
Just 60 days, Your Honor.
How many?
60 days.
60 days, thank you. So, Mr. Tanner, the attorney is asking for 60 days discovery. That means that he'll likely send you written requests for information, whether that be questions or copies of documents. You'll need to respond to that. And likewise, if there's something that you want from your office, you need to send it to them in writing.
okay.
60 days puts us at July. The court does civil cases on the first Tuesday of the month. So Mary Ann, whatever the first Tuesday of July is, July 6th.
Yes, ma'am.
July 6th, 2021 at 9 a.m. will be the motion date or the final pretrial date. Mr. Neal, if you would submit an order for discovery for 60 days to the court.
Will do, Your Honor. Thank you.
Thank you. Anything else, Mr. Neal?
Not at this time, Your Honor. Thank you for the court's time.
Anything else, Mr. Tanner?
No, ma'am. So I just wait to hear from you, that you guys will send me a letter in the mail about the next date?
The court will send notices, correct.
All right, thank you, Your Honor.
Have a good day, sir. Have a good day, Mr. Neal.
Thank you, Your Honor. Have a good one.
Thank you. Back on the record on 211084 GC, Citibank versus Monet.
Good morning, Your Honor.
Good morning again, sir. Miss Monet is here. And it looks like audio and video should be working, but I don't see. Miss Monet? Miss Monet? Her audio and video are connected.
And I could see her photo, I could see her picture, but it was frozen and I couldn't hear anything if she was saying anything.
What I will do is remove her and she can reconnect and maybe the connection will be a little bit better.
Okay.
Hello?
Miss Monet? I know. We have a phone number for her.
Yes.
Oh, wonderful.
There she
ma'am.
is.
Am I in the breakout room?
No, ma'am, you're in the main courtroom. Your video
Can
is
you-
not showing. I can hear you. I
Can
just
you
can't
hear-
see you.
Can you hear me?
Yes, ma'am.
Do you want me to come out and come back in?
Yes, ma'am.
Do you want me to leave and dial back in?
Yes, ma'am.
Okay, you say yes. Okay.
Yes.
Can you hear me now?
Yes, Miss Monet.
There you are.
See you. Wonderful. This is 211084 GC Citibank versus Monet. I have your appearances already. The parties have been into breakout room previously. Are you ready to proceed, Mr. Groner?
We can proceed, and then maybe after we're done with you, we can be placed back in the breakout room, and hopefully I can finish our correspondence with each other.
Okay, the matter was scheduled for pre-trial this morning. Where are we?
Your Honor, I'm just going to ask for a period of 60 days of written discovery. I think that would benefit the parties, and hopefully Ms. Moner can receive some information that she's requesting, and also Citibank usually has us submit some written discovery to the defendant in these matters.
Ms. Monet, did you hear what the attorney just said?
Well, my question is, Citibank was willing to reinstate their settlement with me. And that's what I am requesting, that it be sent, that my case be sent back, and that my settlement sent back to Citibank, and my settlement with Citibank be reinstated.
Ma'am, that's actually a conversation you would have with Citibank's attorney. What the attorney is asking right now is for 60 days of written discovery. That's an opportunity for him to send you questions to answer or request for documents. And likewise, you could do the same. You would have to send him any requests for documents or questions in writing, and he would have to respond, or he would respond on behalf of Citibank.
So I had sent him with my response with the court documentation, and was he able to respond before this court date?
No, ma'am. There was no order for discovery. Discovery is not automatic in district court, which is where we are. The parties have to ask for it, and the attorney has now asked for it, and he will submit an order granting 60 days written discovery, and discovery will commence. So if you had some questions for him, you can follow up with those going forward. And if you wanted to have conversation with him regarding the reinstatement of the settlement, that's a conversation that you can have outside of this hearing this morning.
So how does the hearing conclude then?
The hearing concludes with the court setting a final pretrial date towards the end of discovery, which is 60 days from now. I only do civil cases on the first Tuesday of the month, and when you have 60 days of discovery, that takes us to July, and I think that date was July 6th, Marianne?
That was the date from the previous case, Your Honor.
That's July 6, 2021 at 9:30 a.m. And what'll happen in the meantime, Ms. Monet, is that the attorney might send you some written either questions or requests for documents, and you can do the same. It's also an opportunity for you to have discussions about settlements or anything else that you want to have discussion about. The court can't force a settlement. So that's why I'm saying the conversations between you and the attorney.
And if you could put us into a breakout room following the conclusion of this matter, Your Honor, I can kind of follow up with the defendant regarding that.
Ms. Monet, do you understand what I'm saying? Oh,
Not again.
I was gonna say there might be a technology issue. Did you have an opportunity to get her contact information?
I know we have it. We have it on file, Your Honor.
It's on the answer.
Yeah.
Ms. Monet?
Did you want us to file an order granting the discovery then, Your Honor?
Yes, sir. Thank you.
We will do so then.
And because of this technology issue, I don't know that it's beneficial to try to put you back in a breakout. I can still see her, Ms. Monet.
We just can't hear her or anything again.
We're not connecting.
Yeah.
So what I will do is I will deem the matter concluded if Ms. Monet calls. I'll leave our Zoom open. If Ms. Monet calls back in or reconnects, I'll tell her to get in touch with you, but I would encourage you to get in touch with her. Otherwise, I'll see you back here on July the 6th.
Sounds good, Your Honor.
Thank you.
Appreciate it. Thank you.
Okay.
You too.
Thank you, Mary Ann. That concludes our civil docket.